Well, the reason why it's so complex and so excellent a system is because of the complexity of the court system from the top to the bottom. And it takes a little bit of concentration to understand it. First of all, you have to understand that there is a sort of pyramid. There are courts right at the bottom, local courts, the sort of thing at the level of parish council nowadays, or some local area where you can sort out very minor grievances. And then you go up a level to a magistrate's court nowadays, for example. Then you go up another level to a county court nowadays. And then you go up to one of the courts that meet in London. Now there's that idea of sort of a hierarchy of courts was very early established. So you have levels of courts, some of them meeting in each village, like the manor court, some of them meeting in the local town, like the magistrates, some of them meeting in this local city, and some of them meeting in London. So 4 or 5 levels. Secondly, the court system is split between the ones which administer church law, the ecclesiastical courts, and those that administer secular law, all the other ones. So that's a big split. And then you have another split between those courts which administer the common law of England, that is the customary law, the customs of the peoples of England, and a few laws that have been passed by Parliament. That is common law. And that is very rigid and set down. You do this, you don't do that, you must do that, and so on. And it's all based on evidences, proofs, witnesses, juries, very, very carefully worked out. But in order to have access to it, you have to have a watertight case, and the thing has to be straightforward. Now, that is law. Quite early on in England, and this is one of the great peculiarities, something that wasn't developed anywhere else, quite early on, they discovered that this doesn't really deal with justice. Because justice is about fairness, about equity. It's about how people, in their secret moments and in their forgetful moments, and because they are weak and because they don't have many friends, how they should behave towards each other. Now, most legal systems try and force together justice and law. The English, early on, about 500 years ago, realized these were different things. And you won't necessarily get justice by going in front of a large, bewigged old man. We do this now with child abuse cases. Children are taken away and put in another room, and you watch it through television and so on, because it's realized that if they went through the normal process of law, there would be no justice. Now, in the past, this is exactly what happened. If some old widow felt that some neighbor was oppressing her, and she lost the deeds for her bit of land, and she couldn't actually prove it, but all her friends said, yes, yes, she's been in this cottage forever, and he's a horrible old so-and-so trying to throw her out. She would make an appeal directly to the Lord Chancellor, and she would come and sit and talk to him one-to-one, face-to-face, and say, look, this isn't fair. Why should I? I've been there for 30, 40 years. Why should I be thrown out? I can't prove it. And he would say, yes, notwithstanding, there's no proofs, notwithstanding you're a woman, and therefore don't have exactly the same rights necessarily as men, notwithstanding all these things, I will give you justice. So a whole system that built up into courts like the Chancery Court and the Court of Requests for poorer people, built up alongside. Dickens's Bleak House is about Chancery and the final stages of Chancery, but it was a very important system. So for a long time, we had the idea that you could get from our legal system not only law, straightforward, but also justice, and that is important. So you've got the ecclesiastical, secular, all the different hierarchy of courts, and also equity, as it's called, which is to do with justice and fairness, and the common law.